Today we're delighted to have this panel about labor laws in China. As you know, it's 10 years since the first set of labor laws were implemented, and we have two very expert people to discuss this with us. Geoff Crothall has worked for the last 10 years at China Labour Bulletin, which is a Hong Kong-based NGO dedicated to supporting the workers' movements in China. He currently serves as the group's communications director. He lived himself in China in 1984, and he was the South China Morning Post Beijing correspondent between 91 to 96. I should also mention that Geoff is on our Press Freedom Committee and a very loyal member of this important committee. We appreciate his contribution there. Jonathan Isaacs heads the Baker McKenzie China Employment Practice. He has co-authored the leading treatise on Chinese employment law in English, and you can read his insight on labor and employment issues in many newspapers and magazines, including Financial Times, Wall Street Journal, etc. And talking about this, his work can be read in the book, which is for sale at the end of the room, which Thomson Reuters put together. It's basically a book explaining the employment law and practice in China. And today it's on sale with a special discount, so don't miss this opportunity. Geoff was saying that it's a book that he uses on a daily basis. So without further ado, Geoff will start by introducing us to what's happening in China. And then Jonathan will take over, and after that we will have a Q&A session with the two of them. Thank you very much. Please welcome Geoff.
I'm going to sit here and then put the computer in the way. Okay. So let me just take that. Okay. Thank you, Florence. Thank you, everyone. I thought we'd begin by just taking a quick look at the map that you can see on the screens up ahead. Now, from here, you can see that it's not just the Pearl River Delta where workers are going out on strike. It's pretty much everywhere in China, from the coastal provinces, inland provinces. It's construction workers, it's factory workers, taxi drivers, delivery drivers, people working in hotels, people working in supermarkets, and just yesterday, in fact, we haven't even had time to put this latest development on the map. There are about 1,000 teachers in more than 10 cities across China who went out on strike staging demonstrations yesterday over a wide-ranging and long-standing issues. And it's important to point out that although this is the last 6 months and we already have 900 incidents marked here, this is just the tip of the iceberg. This is just the incidents that we can find with our limited manpower searching social media in China. The actual number, this probably represents only about 10%, maybe just 5% of the actual number of strikes and protests in China. So how did we get here? As we mentioned, 10 years ago, China passed the labor contract law, which was supposed to solve all of these problems. It was supposed to provide a framework in which workers and their employers had a clear set of guidelines on rights and responsibilities, and provide workers with protection against the exploitative bosses who had basically been having a free rein for the first couple of decades of the reform era. But problems started even before the law went into effect. The law was approved by the National People's Congress in 2007 and only went into effect on the 1st of January 2008. So what do employers do? They start sacking all their long-serving staff before the law goes into effect, so they don't have to pay the severance pay mandated by the new law. And even after the law went into effect, companies soon found a way around it. They started employing workers as agency workers. Now, agencies, employment agencies, they're kind of at arm's length employment agencies. You work for the agency, but you actually work for the company. They're supposed to only be for temporary labor, but in many cases, people have been employed as agency workers for 5 years, 10 years, and usually they're lower pay levels, poorer working conditions, and less secure employment than formal employees. In fact, that this abuse of the law was so widespread that the Chinese government actually had to amend the law in 2013 to try and resolve the problem. And of course, people just ignored that anyway and just carried on as before. There are other ways around the law. You can hire people as individual service providers. This is particularly common in the so-called gig economy, where you're not actually a worker, you are providing a service to the company. Or you can just hire interns. This is particularly popular with companies like Foxconn, who, when they have a new order from Apple and they need to get a rush order out for a new model, you just hire a bunch of high school kids to do the work for you. They're not technically workers, they're not technically students, they conveniently fall into a little grey area where they have very little protection. Another way around the law, there are quite strict provisions on overtime. So a lot of companies now are employing people on flexible working hours, which if they're not absolutely illegal, then they're pushing the law to its furthest limit. Then again, many employers just ignore the law entirely. And they can do this because local government officials are far more concerned with maintaining a healthy business environment, maintaining solid economic growth in their locality than they are in actually abiding by the law. There was, to be fair, an initial push in 2008 to make sure that China's most vulnerable workers, rural migrant workers, did get covered by the law and did get proper employment contracts. And now a quick word about why it's important to have an employment contract is because that establishes an employment relationship. And if you can't prove you have an employment relationship, that can cause a whole lot of problems further down the line. Now, in 2009, the government, after this initial push, managed to get the percentage of migrant workers with a contract up to 43%, which was better than it was before. Unfortunately, nothing really improved after that. And 2016, I should say, where we have the most recent figures, the proportion of migrant workers dropped to 35%. The one good thing, I think, to come out of the labour contract law is that it inspired many more workers to use the law themselves for their own, to protect their own rights and interests. So immediately after the law went into effect, the number of disputes that went to labour dispute arbitration committees doubled. It was around 300,000 in 2007 and 600,000 in 2008. And it's now currently around 800,000 each year. And these are just the ones that are dealt with in-house. There are another 500,000 or so which are dealt with outside the actual committee structure. And these are just the individual cases. These are just individual workers with a grievance against their boss. When we look at collective disputes, which are shown on the map, we've seen a pretty high level of disputes over the last 5 years. And in many of these cases, you see workers using the law to frame their demands. So perhaps the best example is in 2014, Walmart, the American retail giant, decided to close down one of its stores in a central Chinese city called Chengde. And this is what they did all over China. They just unilaterally announced that the store's closing. This is your compensation offer, take it or leave it. Well, the workers didn't take it, and they pointed out that the procedure for closing down the store had not gone through proper legal channels, and as such, Walmart had to pay them double compensation, which is prescribed in the labor contract law. And they staged a protest, which went on for about a month. It eventually did go to arbitration, and Walmart did win that case, but only after it agreed to pay the workers an extra 3,000 yuan a month in compensation anyway. So I don't know how much they spent on legal fees. Perhaps Jonathan might know. But it was certainly a lot more than it would have simply cost to abide by the law in the first place. Now, I think the important point to make is all of these cases that you see on the map, the vast majority of them are related to employers breaking the law. So, Keegan, if we could look at the numbers for 2017, I think we've got 1,256 incidents. 82% of those are related to wage arrears. That is, employers not paying their staff on time or in full. And only 4% are related to demands for pay increases. So that goes to show that workers are not greedy rabble-rousers. You know, they're not demanding more than they deserve. And that's not to say they're happy with their wage levels. They're certainly not. But the vast majority of the cases simply are they have to go out on strike. They have to protest because their boss is at fault. Their boss is breaking the law. Now, all the evidence that we've seen shows that employers are ignoring the law. Government officials are doing very little to enforce it. So what do? Well, a lot of people now about, well, we have to reform the law. We have to amend the law. We have to tinker with the law somehow. I don't think that's going to work. What the Chinese government really needs to do is address the fundamental imbalance of power in the workplace. Now, while it's important that workers do have individual employment contracts, for the reasons that I outlined before, it's even more important that they have collectively negotiated contracts that can establish and guarantee a fair and mutually beneficial working environment. China's workers have shown over the years that they're more than capable of bargaining collectively. At China Labour Bulletin, we've been involved in more than 100 such cases over the years. But that is just a drop in the ocean. What we really need is for the official trade union in China, the All China Federation of Trade Unions, to step up and actually bargain on behalf of its members. Whether or not that will happen, I think we can discuss in the Q&A, or Jonathan might have some ideas about that as well. Okay.
Thank you, Geoffrey. I don't disagree with anything that Geoffrey said. I'd just like to supplement with some more information based on our own experience representing mainly on the employer side what we've been seeing on the employee relations front. Basically, in terms of employee relations, what we see is there's a tale of two Chinas. There's the more vulnerable blue-collar workers who mainly work in manufacturing, construction, sanitation, janitorial type work. And then you have a second category, more white-collar workers or office workers, mainly based in urban areas. And the picture that we see in these two different groups is very different. For office workers, white-collar workers, the ironic thing is that this law, the labor contract law, they've been the main beneficiaries of this because they've been the ones who are been most aggressively asserting their rights. So the ones who were supposed to be protected by this law, the most vulnerable blue-collar workers, as Jeff was saying, a lot of times the law hasn't been very effective in protecting them, but it has been quite effective in protecting the rights of the more white-collar office-type workers. And I think there's a few reasons for this. Number one, the white-collar workers, they have more money to hire lawyers to assert their claims in front of the labor arbitration commissions and the courts. They're mainly based in urban areas where the courts and the arbitration commissions are more professional. And they have the time and the inclination to fight these things to the very end. The government actually tried to make bringing claims easier. They eliminated all fees for bringing claims to arbitration, so you pay zero fees. But even with that, if you don't have money to pay a lawyer and you're not very sophisticated about the law yourself, it will be harder to assert your rights. Whereas if you do have money to hire a lawyer, you can cause a lot of trouble for companies. And on paper, at least, the law is quite protective of employees in China. And in fact, that's one of the reasons whenever chambers of commerce like AmCham or the European Chamber of Commerce, when they do surveys of their members, what are the main difficulties about doing business in China? HR or employment concerns always ranks, in the top 5 whenever they do those surveys. And Jen mentioned, the drastic increase in the number of claims that have been raised by employees. I saw some different statistics issued by the Ministry of Human Resources and Social Security. They issued the number of claims that have been heard by the labor dispute arbitration commissions, either that they made a decision on or that they've just ended up mediating. So that may explain some of the difference in the statistics. But 2007, what I saw was 500,000 claims that ended up being handled. And 2016, which was the last year that we had full statistics on, they claimed it was 1.77 million. So the number of claims that were raised seem to have gone up by more than three and a half times. The other interesting thing to note is, overall, when the claims do get heard, it appears, or at least the perception from the companies is that the arbitration commissions and the judges are more pro-employee. And there are some statistics to back this up. When, for example, the Beijing Intermediate People's Court number 1, they issued some statistics last year. They said in the cases they've handled, 70% of the time, employees won in whole or in part. Pudong District in Shanghai, the district court there, 70% again, the employees won. Luohu District in Shenzhen, it was 74%. We don't have nationwide statistics, but overall our impression is the employee wins the majority of the time when a claim is actually brought. So why, in that type of situation, why are there still this widespread noncompliance, particularly for blue-collar workers, aside from the fact that they may be less likely to actually bring a claim, and it's less effective when they do because they can't afford legal representation. I think one of the main reasons for that is a lot of the types of noncompliance, the way the law is structured, you can't actually bring a claim to arbitration for those types of noncompliance. For certain types of noncompliance, you could bring a claim, like if they didn't pay you overtime compensation, you could sue the company. But for other types of noncompliance, you have to go to the local labor bureau, and you can only get administrative relief from the local labor bureau. So you can't actually just sue them in arbitration or court. And the issue is the local labor bureaus, they have so many companies within their jurisdiction, they themselves cannot monitor everything that is going on within their jurisdiction. There's also the fact that they don't want to scare away business, but they simply don't have the capacity to monitor everything that's going on within companies. So for those types of violations where the only route is administrative, you're going to get less enforcement for those types of complaints. So I'll give some, examples. One of the biggest issues is social insurance. For example, pension insurance, medical insurance. This is the basic benefit that all workers need for their basic, welfare. A local payroll agency in China last year, they did a survey. A large-scale survey. How many companies are compliant, actually make the contributions in full? And the result of that survey was a whopping total of 24% were fully compliant, right? So more than 3/4 were non-compliant. So that's what, one, and again, social insurance, the ability of an employee to bring a claim to arbitration or court is very limited. The main route of enforcement is the Labor Bureau. And so they'd have to submit, go to the Labor Bureau to submit a complaint. Another type of violation, excess overtime hours. Under the law, you can only work 36 overtime hours a month. That's actually, by international standards, quite low. But the non-compliance, particularly in the manufacturing sector, is quite widespread with that requirement. And the reason there's little enforcement is because, again, you can't sue for that violation. The Labor Bureau comes and issues a fine for that. And the Labor Bureau, they're not going to act unless they receive complaints from the employees. Again, because they can't monitor this, and also because a lot of employees in practice, they want to work more OT hours, get more compensation because the base salary is so low, so they make a lot of their money through OT compensation. So they don't want to restrict their OT hours too much. And then another common issue, which Geoffrey already mentioned, is the use of agency workers. There was this big hullabaloo back in 2012, 2013 when they amended the labor contract law saying, we're going to greatly restrict the use of agency workers. And the biggest restriction was maximum 10% of your workforce can be hired through agency workers. This is a very clear, bright line rule. And a lot of our clients were very, very worried about this because they were hiring, through agencies a lot of their workforce. And actually the biggest, use of agency workers were actually state-owned enterprises. So there was a big push on this, and they actually had been lobbying against, these restrictions for years. But they finally imposed this very clear, bright line restriction. And then, so a lot of our clients, they restructured their workforce. They were worried about this. And again, the remedy is not a lawsuit by the employees, but it would be the local labor bureau imposing a fine. And the fines can be quite high, up to 10,000 renminbi per worker. So if you have lots of agency workers, that could add up. So this had a lot of teeth. But since then, we haven't seen a lot of enforcement. So there's been a lot of, companies breathing a sigh of relief. They, held back on restructuring their workforce after the initial fear. This hasn't been a major issue. And that's mainly because the labor bureaus have not been really auditing this issue and enforcing it. So I think that's, something within the law that's, one key feature why a lot of these abuses of labor rights is still widespread. Geoffrey also mentioned collective bargaining, and collective bargaining may be one of the ways to push to, better protect workers' rights. The way collective bargaining works right now in China, there's, especially compared to other countries, there's a lot of deficiencies, I would say, or holes that means it leads to the fact that it's not as effective as it may be in other countries. And the main deficiency is there's no final resolution mechanism. So say the workers collectively have a grievance against the company. For example, maybe there's a labor right violation, or maybe they want higher pay. And then they demand collective bargaining. Now, under the law, if they make a demand, the company has to agree to start collective bargaining with them. Under national law, it's within 20 days. Some local regs have different timelines. So that's pretty, basically the employees could force the company to collectively bargain. But then what happens if you can't reach an agreement? You reach an impasse. The law just says, oh, you can get the Labor Bureau to come in and mediate. But then what happens if there's still an impasse? Who knows? No one knows. How do you finally resolve this? In other countries, the workers may go on strike, and that way put pressure on the, But in China, there is no right to strike in the law. There used to be this vague right in the Constitution, but that got taken out. There's no right, there's no protection for striking workers. And the government clearly does not want to encourage these type of collective labor actions because it causes instability. Back a few years ago, Guangdong province, the local government in Guangdong province, they actually tried to introduce regulations to protect striking workers, saying, look, if they demanded collective bargaining and the company did not bargain in good faith, they could go on strike and you could not terminate them. That would have been huge in terms of protecting workers' rights. But the central government pretty much slapped them down and said, look, we're not encouraging this. So that provision got taken out of the Guangdong province regulations. So now we're at a point where even if there is collective bargaining, if it reaches an impasse, it's not very effective. And there's no final arbitration, resolution mechanism if the parties can't reach an agreement. So there are some current key features of the way the system that currently works that really weakens, the system. And what we see usually in practice in collective bargaining is, for the most part, even though there are instances where there's real collective bargaining, for the most part, companies and employees may sign a pro forma agreement, submit it, that just repeats the law. They submit it to the local labor bureau, get it approved, and then they say, okay, we've signed a collective bargaining agreement. Stop causing us trouble. We have this agreement in place. So that's what we've been seeing in practice, with regards to collective bargaining. So I'll just end there, and I guess we'll open it up to questions.
Thank you very much. The two talks are very complimentary. Jeff, do you want to stand there as well? Maybe we put the second mic, and I open the floor to questions.
Hi, so Elaine Pickering, Vision 2047 Foundation. So what percentage of these companies that are non-compliant who are being taken to court and things are SOEs? Do you have that? Do you know that?
No, they wouldn't have. I haven't seen any statistics in terms of the type of company. But SOEs, what we've seen is they're some of the worst offenders in terms of non-compliance because they know they could probably get away with it because they're connected with the government in a way private companies are not.
And why do you think there's no motivation on the part of the government, if they want to get sort of things cleared up, to make them model organisations in this respect?
The SOEs?
Yeah.
Well, the SOEs, they still, even though they're state-owned, they also have their own, there's been a push to make them more profit-oriented. So they're not really socialist enterprises. They're state-owned, but they still are meant to make a profit, and so they still want to, and if they go fully compliant with their huge workforces, that would be a huge additional cost for them. And a lot of them already have their, issues with, costs and profitability. And I think from the government standpoint, for what we've seen, particularly in the past year or two, again, their main focus has always been stability, not necessarily protecting, worker rights. So they'll protect worker rights to the extent that it tamps down on worker disgruntlement and it causes instability. But their main concern is stability. So as long as there's not some widespread worker unrest and collective labor action, there's less, I guess, impetus for the government to really crack down on them.
And also just mention the obvious fact, really, that many SOEs have got more power and political influence than the local government. The local government simply can't come in and tell them what to do.
Thanks. Eric?
Yeah, Eric Wishart. So the other end of the spectrum from state-owned enterprises is foreign companies operating in China. I mean, what's their track record? Do they try and get away with things in China they wouldn't try at home? I mean, you talked about Walmart. So generally, what's the track record of foreign companies in China?
In our experience, of course, they're all compliant and very good. They just happen to be our clients as well. No, but yeah, actually, in our experience, I think from the U.S., North America, and Europe, they tend to be the most compliant because they have a compliance culture, and they are very worried also about PR. So even if they could get away with something, they're not afraid of the worker suing them. There's the PR concern because NGOs will focus on particularly the high-profile multinational companies. So they tend to be the most compliant. Foreign companies, say from Taiwan, South Korea, less compliant, and then the domestic will be, sometimes the least compliant of all. So that's why we have a strange case once. It was actually a huge Chinese company. I'm sure you have all heard of them. I won't mention their name, but they acquired a business, or they acquired two companies at the same time, the China business of two multinationals. And all the Chinese workers, I mean, they hadn't announced anything about how they'll treat the workers. The Chinese workers in both companies, there were two separate multinationals, they both went on strike at the same time because they didn't want to work for a Chinese company because the reputation of how they treated workers was, not as good as these, high-profile multinationals.
But in terms of compliance of social security, foreign companies are just as bad as everyone else. I mean, there is one very famous company, I won't mention their name, but you've probably got Apple.
We won't repeat it.
Yeah, They came to see us a few years ago just for an informal chat about how to do business in China, and we were discussing social insurance, and one of their representatives said, "Oh, that's just a joke, isn't it? No one really bothers with that. None of our employees want to have a pension." And that might be true. I mean, if their employees are factory workers who are 25 years old, sure. When I was 25, I had no interest in a pension. But the problem is most factory workers in China now are 30 years old, 40 years old. They have families, they have aged parents. Getting proper social insurance, getting proper medical care, getting proper pensions is absolutely essential for those people.
Jim Seymour, Chinese University of Hong Kong. I'm curious about the assertion that I think you said 70% of the cases, I've forgotten which cases, are won by the workers, and therefore that indicates bias on the part of these. We're talking about courts or arbitration? I've forgotten. But.
It was different courts, so they don't have
Courts.
national statistics. It was different. Beijing, Shanghai, a certain district court in Shanghai and Shenzhen.
But
Yeah.
to my mind, that doesn't indicate bias on the part of the courts, because a worker is not going to bring a case if he received the pay to which he was entitled under the contract. It's pretty much open and shut case. If you were paid what you're entitled to under the contract, why would you launch a legal case? So I would consider 70%. I wouldn't expect it to be any less than that. And of course, I'm wondering about the other 30%. I suppose maybe it wasn't issues of fact or what the contract said, because usually there's no ambiguity there. Must have been issues of fact. You know, you say you worked so many hours, you actually only work so many hours, or some sort of dispute. Am I right about that? That the 30% is issues of fact rather than law? And spell out a little more why you think 70% indicates bias on the part of the courts.
Yeah, right. I mean, a lot of the cases where they do win, you know, it could be a straightforward case where the employer just didn't follow the law. But what we've seen actually, you know, in our personal experience, because we actually handle a lot of these, you know, litigations and arbitrations, is a lot of the time, and particularly, you know, if you deal with Chinese law isn't, you know, on certain matters it is quite straightforward, black and white, but a lot of issues it's not black and white. So we're not talking about simple issues like, did they pay my wages? You know, that's a very simple, straightforward, black and white issue. It's more like, and most of the cases deal with termination. Was the termination legal? And in terms of whether termination is legal or not, the law has some vague grounds where you could terminate, but how you interpret those, whether a certain situation meets that ground, whether the company has valid grounds to do that, that's all not only an issue of fact, but also interpretation of what that ground says. So that, you know, in termination cases, it is oftentimes not a black and white case. And the burden under the law itself, it's not necessarily the arbitrators and judges are themselves personally biased, but the law is definitely weighted in favor of the employees in those types of situations because the burden of proof is on the company to, you know, justify that termination. I mean, I'll give one, you know, example of this. We had it's a very famous company, one of the biggest companies in the world. They had a case in Beijing where they terminated an employee for false submission of receipts. You know, he submitted a claim for reimbursement, false receipts, you know, submitted it. The company later found out the receipts were fake, so they fired him, right? It should be straightforward. The employee claimed, yes, I admit the receipts are fake, but I didn't put the receipts on there. And the company said, how's that possible? You signed the claim form. And he said, you, this multinational company, removed my real receipts. And then you pasted on the fake receipts intentionally so you could terminate me. And then the court eventually sided in favor. They said, yeah, company, how do you prove that he was the one who pasted these receipts on? And the court ruled in favor of the employee. And this was up in Beijing. Beijing is crazy. Shanghai is a bit more reasonable. But so the company was pulling out their hair and saying, how could this possibly be? So that's like one specific example where we'd see, you know, particularly in Beijing and some other cities where the burden is really on the company. And that's why they have this, you know, sentiment that it's, you know, biased in favor of the employee, those types of cases.
Yeah, I would just say, I mean, I tend to agree with you, Jim, that if workers win the case, it's because their boss has broken the law.
Yes, a question from Ernst there.
Ernst there, Financial Wirtschaft, Swiss business newspaper. Can you talk a little bit on the labor law that was reformed in 2007? And what prompted this change? And this maybe related to this question, what role does the official labor union play? Do they have a power basis on their own? They can push for certain reforms, or they have at least some reputation to protect, to be on the side of the workers, or is it just basically part of the machine, and it's more on the side of the state enterprises than of the people they are supposed to represent?
Yes, certainly the All China Federation of Trade Unions is part of the machine. It's a party organization that is loyal to the party first and to the workers second. But there is a beginning impetus now for the official trade union to start acting more like a proper trade union and representing workers where they need representation. So just last year, the All China Federation of Trade Unions set up a new trade union for delivery workers in Shanghai, specifically food delivery drivers, who are some of the lowest paid workers in China and often have the most dangerous jobs as well. These are the people that really do need a trade union to protect them. So that is actually an encouraging sign that this party organization is apparently beginning to take its responsibilities to workers more seriously. These are just baby steps, I should emphasize, but it's a positive development.
How are they recruiting the management of this labor union? How is it recruited? Are they coming up like trade unions elsewhere in the ranks, or do they pick certain people, or are they just encouraging into the organization?
Unfortunately, I mean, you've identified a very important point. It's not a grassroots up organization. It's very much top down at the moment. People are parachuted in, and that's the key thing that has to change if China's trade union movement is to become a real trade union movement. They have to get workers on the ground involved in enterprise trade unions, taking responsibility and bargaining on behalf of their fellow workers. We've seen in the cases that we've been involved in over the years that workers are willing to take that responsibility. The problem is there's been resistance from the official trade union. They don't want ordinary workers to be part of the union. And so that's the thing that has to change.
Could I ask some details about how things happen once there is a claim? I understand it's very different whether it is collective or individual, but you mentioned these basically millions of claims. And I remember this number in India. I think there is about 3 centuries of backlog in the courts. And for what you describe, it seems to be pretty smooth. I mean, how efficient are the courts to deal with these hundreds of thousands of cases?
Yeah, efficiency is not a problem in China.
Okay.
It's the actual professionalism in dealing, with the evidence. Like they deal with it very quickly by international standards. Arbitration claims under the law, they're supposed to deal with it within 45 days, 60 days in more complicated cases. And for the most part, they do deal with it. Arbitrators deal with it quickly. There's some districts in Beijing, like in Chaoyang district, where there's a backlog. But even there, it's a backlog of a few months, and maybe 5 or 6 months to deal with that.
Okay.
So that's arbitration, and then if either party is dissatisfied with that, they bring it to court, and then the courts usually will deal with it within 3 to 6 months. So there's a court of first instance, and after that there's a final appeal to the court of second instance with another 3 to 6 months. So if you exhaust all the appeals, which many disputes don't go all the way that long, even in that case it would be a year and a half to exhaust all the appeals. But a lot of times, if it just goes to the arbitration and no party, goes to the courts, it can be resolved within a few months.
Which is actually pretty good by international standards, isn't it?
Yeah.
Isn't it?
Yeah, I mean,
compared to France,
yes,
sounds faster.
It's definitely fast. Speed is not an issue. Yeah, like I said, speed is not the issue. It's more of the issue of, it's getting better. The courts are definitely getting more professional in the big cities, but in some cases they won't even look through all the evidence, that closely, and so that's why they're able to get through these disputes, quite quickly.
I would just add that a vast majority of cases in labour dispute arbitration commissions are actually mediated.
Yeah.
They're not actually a formal arbitration decision. So it's like, guys, let's come to an agreement. Let's sort this out as quickly as possible. You compromise on this, you compromise on that. Okay, shake hands, get out of here next.
Oh,
Yeah.
really? Okay.
Yeah, so they'll try to put pressure and say, look, if you don't come to a reasonable settlement, I may rule against you, and they'll do that to both parties to try to get them to settle. Because they keep statistics on what percentage of disputes get mediated, resolved by mediation. And the more you resolve by mediation, it's supposed to reflect a better grade, a performance grade for the arbitrators and the judges. So.
I was also going to ask you to comment precisely on the general trend, because I must say I'm rather surprised. I think I was expecting a worse scenario than the one you described. Have you both things improving, or how do you find the trend of the last, say, 10 years, since it's 10 years since these labor laws have been created?
I think things have improved for workers simply in the sense that there's much more of a collective sense of class consciousness is a tricky term, but awareness of workers that they're all together, that they all face the same issues. And I think from a workers' movement standpoint, that is a very positive development. Mm-hmm. Of course, there has been a huge pushback by the employers against that. Okay. But if you listen to the recent pronouncements of the highest levels of the party, I think there is, just listening to Xi Jinping's speech at the 19th Party Congress, I think there is a recognition that much more has to be done to improve basic living standards, improve wages and working conditions for ordinary workers in China.
Yeah, I think, again, like I said at the beginning, it's pretty much a tale of two stories. Things have improved somewhat, for the lowest level, blue-collar workers, but there's still widespread non-compliance with even basic labor rights. Whereas for the white-collar, things have improved, I think, a lot more because companies have to pay a lot more attention to the rights vis-a-vis those workers or employees because they're more willing to sue, and companies are a bit more afraid of that. So I've seen a major shift in terms of how companies treat those types of workers within the past 10 years. And in fact, one of the interesting developments recently is a lot of companies have complained that there's too much protection, particularly against termination for some of their employees. So there's been reports in the Chinese press that they're going to amend the labor contract law to make it easier to terminate, or that's what they said, make the workforce more flexible, because a lot of companies complained it's too rigid, the economy's slowing, we can't manage our workforce, we need more flexibility. So there were reports in the Chinese press, the end of 2016, early 2017, that they're now starting to amend the law, in that respect. So we'll see if they actually do amend it, because I think there will be pushback, from workers if they amend it too much in the company's favor.
We have time for one last question. If you don't, okay, please.
Hi, Greg Turk with Bloomberg. Talking about the mass actions and the incidents that are occurring that you show on your map here. What is the outcome? I mean, what happens to the workers? Typically, after or during these incidents. I mean, are they? What's the outcome? Are they arrested? Are they tortured? What happens?
Well, we can take a look at the number of times that. If I can get this to work.
It wasn't popping up.
It's not popping? Okay. Oh, well, we do have an option where you can look at the number of times the police get involved and the number of times arrests are made. Keegan, off the top of your head?
I just said yesterday maybe 10 to 15% of the times you can see police there, and maybe 5 to 10% are arrests.
Yeah. So if there are arrests in 5 to 10% of these cases, In most of those cases, workers will just get roughed up or taken to the police station for a few hours a day. Occasionally, they will be detained and criminally charged, but not with going on strike. They'll be charged with public order offences, gathering a crowd to disrupt public order, that kind of thing. But in most cases, the police just hold a watching brief. Like typically, if a factory goes out on strike, the police will surround the factory and make sure no one gets out onto the streets and contain that action within the factory grounds. That's their main concern, is to stop these events becoming visible to the outside world, rather than actually trying to resolve them. But in most cases, some kind of compromise agreement is reached. Workers go back to work. Nothing is really resolved at the fundamental level. So 6 months, a year, 2 years later, workers go out on strike again.
Yeah, I would say, yeah, that accords with our experience. I mean, usually the police, if it's purely internal within the factory, the police do not want to get involved. They say this is your own internal matter. Even if the management is being held hostage, there's been a couple of cases, including some we've been involved in, where the management get trapped. And then they call the police, and the police say, "Hey, we don't want to get involved there." But if it spills out outside the factory onto the streets, they are much more likely to get involved because, like Geoffrey said, they see it as a disturbance of public order, and that's when they get really concerned about this. Otherwise, if it's internal, they say, "Look, management, you got to work this out with the workers." Sometimes the local labor bureau will come in and try to mediate. Usually not very effectively, but usually eventually some compromise agreement is reached.
Just to follow on this and the visibility of this strike, a very last question. How does press generally cover these things? You said you only have access to possibly 10% of the thing. Is there a similar general bias sympathetic to these strikes, or is it the other way around?
I would say 95% of the cases that we collect are from social media.
Oh, social media,
Yeah.
not the media.
Yeah, occasionally, like we had local TV stations like noise and disturbance. So if there's a big noise somewhere, they'll go down and cover
it.
Yeah, the official.
But it's not something that is not to be covered.
No, it's
really.
not. It's not the most sensitive issue. It's not demands for Tibetan independence. It's not anything happening in Xinjiang or anything like this. It's just a bunch of workers demanding to be paid.
Please join me in thanking them by a round of applause.